So now let's kind of talk about, let's not kind of do it, let's do it. Let's talk about the court injunction, where it came from, and kind of how we got to this point.
So, two groups of plaintiffs filed lawsuits against the state of Maryland, Governor Moore, various states' attorneys, Anthony Brown. Now, when this bill was passed by the legislature, Anthony Brown, his office gave an opinion, and they said that Senate bill, it is our view, is that Senate Bill 1 is legally sufficient and is not clearly unconstitutional. That's what he said. Some people disagreed with them. There were two groups, Susanna Kipke, and she owns Miss Kipke's Secure Gun Storage, and the Maryland State Rifle and Pistol Association were one group. And then a second group, Catherine, and I apologize if I'm mispronouncing it, Novotny, Maryland Shall Issue, the Second Amendment Foundation, and the Firearms Policy Coalition, they're the second team, filed these lawsuits against the state of Maryland in the United States District Court. So it's in federal court. And it got assigned to Judge Russell. And both sides, there is some minor disagreements between the two sides, between the plaintiffs as to where to fight, what to challenge. Are we challenging under the Second Amendment, the 14th Amendment, things that probably are very boring to you all. But they both challenged it, and they asked for an injunction. Now, an injunction is not the end-all, be-all. Just bear that in mind. An injunction being granted, that means that the court has reviewed the initial submissions by the parties and has determined that there are some serious issues that need to be reviewed. Now, they broadly challenged a whole bunch of Maryland firearm laws and regulations. So this is going to be a little bit broader than just Senate Bill 1. But for an injunction, the court considers four things: the likelihood of success on the merits, a likelihood of suffering irreparable harm in the absence of preliminary relief, the balance of the equities tip in the party's favor, and that the injunction is in the public interest. So, number one, are you likely to win if this goes all the way to trial? You can have the best arguments in the world, but if it's not likely to you win, too bad. Number two, the likelihood of suffering an irreparable harm in the absence of preliminary relief. So if Judge Russell had not granted an injunction, you could not carry a firearm until this was resolved. These kinds of cases usually take months, if not years. So there would be suffering. There would be, I'm sure, unfortunately, someone would witness a crime, be a victim of a crime, and not have a firearm with them for their own self-defense or the defense of a life of another. The third one, it's a legal standard. The balance of equities tip in the party's favor. And that's a fancy way of saying that when we consider what would be equitable or what would be fair, what would be the fair thing to do, it goes one way or the other. And then once again, that the injunction is in the public interest. So Judge Russell heard all of the arguments of all sides, and they challenged a lot of the parts of this law. We won't get too much into it from the outset of the various rulings of the judge, but they really, really came hard at pretty much the whole thing. They challenged the healthcare facilities. They challenged the schools. They challenged the private property rule, as we discussed. They challenged the casinos. They challenged the museums. Pretty much everywhere that one could challenge. And right up until October 1st, I thought this was going to be enacted. It was enacted, go into effect. And then the Friday, right before October 1st, Judge Russell issues this wonderful, read it when you want to fall asleep, but it's still wonderful, 40-page opinion detailing his thoughts on whether or not this law is, as Anthony Brown said, legally sufficient and not clearly unconstitutional.
And they made it severable as well.
Yes, yes. The law itself, just another boring lawyer thing. The law itself, in the very end, contains a clause that says if a court throws out any section of the law, don't throw out the whole law. We want the rest of the law to stay in effect. And you only put that in the law if you are worried whether or not it's constitutional. So under Bruin, Judge Russell is looking at in 1791, when the Second Amendment was enacted, and in 1868, when the 14th Amendment was enacted, are there relevant, similar to historical regulations, analogies that can be drawn by the state to support regulating where you can carry firearms? And Judge Russell, and we're going to do this in a couple minutes, went through each and every challenge that was brought forth, and similar to baseball umpire, called balls and strikes, threw parts of it out and kept parts of it in. Now, an injunction, once again, is only the first step. There has not been extensive live witness testimony. There hasn't been cross-examination. There have been motions for summary judgment ruled on. So this is going to be quite a process, and this will continue to evolve. After Judge Russell renders an opinion, I'm sure the loser or the winners are going to appeal it to the Fourth Circuit. That's down in Richmond. They're going to take years before they render an opinion in all likelihood. And then whoever loses there may ask for an en banc. That's a fancy way of saying ask all the judges of the Fourth Circuit to review the opinion. And whoever wins or loses from there is going to appeal it to the Supreme Court, I'm almost certain. This is a 5-year process, probably. So while it may appear clear to some of us, while it may appear hazy to other ones of us, this is not going to be resolved today or tomorrow. And Judge Russell's injunction is good today, but you need to be very cognizant it may not be good tomorrow. And when it is like a light switch, when it is flipped, that is that. So be very careful. What you could do on Friday, you may no longer be able to do on a Monday. So just bear that in mind, and if you want to be lawfully carrying a firearm, stay cognizant of developments with the court.
So the injunction essentially puts those matters that were enjoined on pause
Yes,
until such time as they're unpaused or they're gotten rid of altogether.
yes. And anything that is not unpaused pursuant to the law remains in full effect.
All right, so now would be a good time to take that intermission.
Sure.
So we're going to take 20 minutes, intermission, use the restroom, grab something to drink, and at 7:30, we'll be back here and we'll actually talk about what was enjoined and what its effects actually are. So, thank you. Okay, all right, we're going to go ahead and get back started. So, everybody take their seats. Okay, so, you got a lot of papers there.
I do. 40 pages of wonder in front of me.
Fantastic. All right, so what do those 40 pages of wonder tell us?
So, looking for Maryland's historic regulation of firearms, we need to look to 1715, where Maryland had a colonial law that imposed criminal penalties against anyone of evil fame or a vagrant or dissolute liver that shall shoot, kill, or hunt, or be seen to carry a gun upon any person's land, whereon there shall be a seated plantation without the owner's leave, having been once before warned. That's what we got to work with, everyone, so please, careful attention. Do we need to read that again, or we get the gist? So, these plaintiffs, and let's talk about some other areas we don't cover yet. In Maryland, this is outside of Senate Bill 1. You cannot carry firearms in state parks, state forests, Chesapeake forest lands, property owned by the Maryland Mass Transit Administration, welcome centers, rest areas, scenic overlooks, roadside picnic areas, public school property, property of state buildings, Camden Yards complex, casinos, and a demonstration in a public place or in a vehicle that is within 1,000 feet of a demonstration in a public place after being informed by a law enforcement officer that a demonstration is occurring and being ordered to leave the area until the individual disposes of the firearm. These were all things that predated Senate Bill 1. So the plaintiffs challenged all of this, both under the Second Amendment and under the 14th Amendment. And the court sat down and went through them one by one. The court says, and this may be news to a lot of people, not to people in this room necessarily, but the plain text of the Second Amendment protects the individual's right to carry a gun for self-defense outside of their home. And as we view everything through that optic, let's go through them one at a time. Stadiums, racetracks, amusement parks, and casinos. The court said, despite arguments to the contrary, there are historic laws that would support that, so you cannot carry a firearm at a stadium, racetrack, amusement park, or casino. They said government buildings. They said there's ample historic regulation of laws forbidding you carrying firearms in government buildings. Loser there. School grounds. They said, the Supreme Court said it is well settled law that they can prevent you from carrying firearms on schools or school grounds. So that is a loser. I was a little bit shocked by this. Museums. The court said there is well settled law that you cannot carry a firearm in a museum. Mass transit facilities, well settled law, cannot carry a firearm there. We did have several wonderful victories, though, with Judge Russell in the injunction.
So all is not lost.
All is not lost. He did have some major rulings that would be helpful. Number one, locations selling alcohol or cannabis. The defendants claim that, banning the carrying of firearms in bars has historic support. They were able to find a law from 1890 in Oklahoma that said you could not carry a firearm in a bar. They said that's not good enough. So it's 1890, it's Oklahoma, and because Oklahoma, not to get too complicated, but Oklahoma has traditionally been a Native American tribal land that is not analogous to what we have here in Maryland. So despite all the arguments, we don't want drunk people shooting each other, despite the fact that it would be illegal to do that already. Locations carrying, selling alcohol, you can carry a firearm there. Public demonstrations. They said, there's ample evidence of this. There's cases where, of course, we're all aware of, where there has been violence at public demonstrations. The court said that historically, there have actually been laws on the books that required you to bring a firearm to a public demonstration, not banning them. So, as of this second, the 1,000-foot rule, that once again, not Senate Bill 1, pre-existing, 1,000-foot rule is enjoined. And then finally, I would have preferred to win on everything, but what's going to probably affect the vast majority of you in your daily lives is the private building consent rule. That's the one if you're going to visit your brother, your mother, your father, going to see your neighbor, going to the bank, going to the CVS. They said that you cannot prevent people as a default, the populace, from carrying firearms into those establishments and put the onus on the establishment to permit it. So, if the establishment conversely wants to ban you from carrying firearms in there, I just happened to walk through the main entrance of this wonderful establishment. There's a sign there that says no firearms on the property. That is their right as a private entity to do so. But you cannot, according to the court, presumptively ban the carrying of firearms at everyone's house, business, etc., without their consent and without putting the onus on them to post a sign to allow people to exercise their Second Amendment rights. So there is going to be a great multitude between that of locations where you could, as long as this injunction is in effect. And remember, it is but an injunction. It can go away as quickly as it came. So make sure you are following it. Make sure you are supporting the Second Amendment. But while that is in play, you are free to carry at a wide multitude of private establishments in the state of Maryland without requiring express permission or there to be signage. If that is reversed, that goes back into effect. But until that happens, that is a tremendous victory.
So pay attention to what's going on because things can and do change, both for the good and the other way.
Unfortunately.
Right. So all is not lost. Don't hang your heads in defeat. So what we'd like to do now is we're going to go ahead and open the floor up for questions.